seated, please. Thank you, Marshall. As you may have been informed, the third case on today's docket has been unavoidably canceled, so we'll hear the cases in the order, except the Dr. Fox case will follow directly after Boza versus Carter. We will take a short, maybe 10-minute kind of comfort break after the Boza case, and then the court will reassemble here on the bench. I want to welcome you all to today's session of oral arguments at the District Court of Appeal and remind everyone that we stream these arguments live daily at 1dca.org, and also the arguments are archived. So some night when you have nothing else to do and you're sitting around with your children or your parents and family, you can say, this is the case I argued up at the First District Court of Appeal. And there it is. First case is Randall versus Bisbee-Baldwin. We'll hear from the appellants.
May it please the Court, David Healy for the appellants, Doug and Julie Randall. I'd like to reserve 3 minutes for rebuttal, if I may.
Did Mr. Wheeler explain the clock to you? The bench does not control the clock in this courthouse. The deputy clerk has complete authority over the clock. And when that light comes on in the middle, it says sum up. That means you are not into the last 3 minutes of your argument. That means you're into your rebuttal time, is what that means.
We've been
come on in 3 minutes.
May I proceed, Your Honor?
Yes.
Your Honors, as perhaps a sign of our times, this is a mortgage foreclosure case in which my clients seek reversal of a final judgment of foreclosure entered following trial over in Duval County that ordered the foreclosure of 4 separate parcels of land owned by Doug Randall, 3 in St. Johns County, 1 in Duval County. We respectfully suggest that reversal is required in this case for 2 primary reasons. First, and most importantly, perhaps, the circuit court erred by, before trial, striking the Randalls' affirmative defenses of unclean hands and estoppel, as well as Mr. Randall's counterclaim for fraud in the inducement, finding generically that a Florida statute of frauds barred such claims as a matter of law. Secondly, and as an independent ground for reversal, we seek reversal of the judgments finding that all 4 parcels should be sold if a sale is required, all in one block rather than serially and separately, as we argued was appropriate. By way of brief background, Bisbee-Baldwin is the lender, lent the Randalls $2.35 million back in 2003 that Mr. Randall used to acquire title to 2 additional parcels of land in St. Johns County for development purposes. He pledged 2 other parcels he owned as collateral, and based on the trial testimony given below, the collective value of the parcels by MAI appraisal was over $9 million, far in excess of the amount of Bisbee's claim. There were some permitting issues. Specifically, the prime piece required various DEP and Army Corps of Engineer permits that took longer than originally anticipated by the parties to obtain, and therefore development was delayed. Bisbee extended the loan, therefore, on several different occasions, culminating, importantly, in a final extension evidenced by a 1-page extension agreement that was entered into.
Counsel, you would concede that on the date that the extension agreement sued upon was entered, was this the 3rd extension of this loan?
I believe that's correct.
You would concede that the loans were either in default or unpaid at that time?
No, it was not in default. We had paid all of our payments, and there was no declaration of default, Your Honor.
Well, I said or unpaid. Whatever the principal that was due at the termination had not been paid.
The principal had not been paid. However, the lender had not declared default, and indeed, in the extension agreement, extended the payment.
Well, sure, they didn't declare default because as an alternative, they negotiated 2 extension agreements. But here's the question: the extension agreement, they rolled over or continued the time due on this amount of $2.3 million, and I know that the due diligence money is in question. But my question is, what is the remedy that you would want from the court in the event that we reinstated your affirmative defenses and your counterclaim?
To hold the lender to what it represented it would do.
Well, how's that going to look? What does that look like?
What it's going to look like is it's going to find that the lender does not have a right to foreclose.
So it's just going to exist as a note, as a personal obligation of your clients to Bisbee-Baldwin?
What would exist, Your Honor, is we would ask the lender, as was represented to us, that it would extend the loan for another 12-month period of time.
You didn't ask for, did you ask for specific performance?
We did not ask for specific performance.
Then you're not going to get specific performance. So I go back to my question, is what is the remedy that you seek?
The remedy that we seek is that the lender may not foreclose until it lives up to what its promises were to this
That
borrower.
sounds like specific performance to me.
Well, we would, in that case, we can...
And besides, an affirmative defense is normally an avoidance of an obligation that would otherwise exist. So I ask you again, what is the remedy that you would seek in the event we reinstated your affirmative defenses that the trial court struck based on the statute of frauds?
To, in equity, not allow the lender to foreclose this party.
What happens, though? I see what you're saying, but
Yeah.
I'm trying to understand what happens out there. They've extended the loan 2 or 3 times.
Correct.
They're holding this piece of paper here that's now, I don't know, I guess the final judgment is way up. It's close to $3 million, I think.
It's probably well north of that now,
So
Your Honor.
what do they do if you're successful in your affirmative defenses?
They reinstate the loan, go ahead and reestablish the interest reserve, go ahead and establish the road building fund, which my client has testified was the only reason that the property was not developed and sold or refinanced. We are not asking to hold Bisbee-Baldwin to a perpetual loan. What we are saying is that having...
It seems like a fairly complex set of conditions that you allege were negotiated prior to the execution of this March 2nd, 06 extension agreement.
That's correct.
Yet you don't think the statute of frauds is any sort of a problem there?
The statute of frauds is not a problem, Your Honor, because, first of all, it does not apply under the uniform case law of the state to the affirmative defenses that we've asserted. It only bars claims or actions on a credit agreement. We respectfully suggest we did not bring an action on a credit agreement, which may be answering the court's question belatedly. May have been a good reason we didn't bring a specific performance claim below. However, we are allowed to assert defensive claims, affirmative defenses, based on the lender's representations, which we did. And to date, every appellate court in the state has found the bank's statute of fraud does not bar parties in my client's position from relying on those complete affirmative defenses.
And those cases involve situations where there were conditions that were allegedly conditions of a loan that were negotiated before the closing of the loan and are not reflected in the loan documents. You have cases that say that.
Yes. For example, my favorite case, and it's cited in the briefs, is the Griffith case. I believe it's out of the second DCA, where affirmative defenses in a foreclosure suit were recognized as proper, where the lender, in entering into a bridge loan credit agreement, allegedly promised to provide permanent financing at the end of the bridge loan period, and the borrower, relying on that, entered into it, and then the lender never entered into permanent financing. Very similar to our case, we were induced, our theory of the case, to enter into the extension agreement, agreeing to pay a substantial fee. And like the lender in Griffith, we're asking them to come in and do the other half of what was represented to us. So the point to all this phase of the argument is that we asserted proper affirmative defenses to the lender's own foreclosure claim. They should not have been struck under the bank statute of frauds, and at a minimum, the judgment should be reversed for that basis and sent back so we can argue those defenses to the trier fact. The other claim that we also seek reinstatement of is the fraud and the inducement claim. And, you know, we also argue that the bank statute of frauds does not bar what is properly classifiable as a completely independent tort claim. In other words, it's not an action on a credit agreement, but it's an action on what we are claiming were misrepresentations of present fact, namely the lender's representative statements of they would go ahead and renew the loan on the conditions stated, which we claim were not sincere when made. Under Florida law, that is properly classified as a misstatement of fact, and as the Florida law has developed, particularly in the economic loss arena, in the HTP case and some of the other related doctrines, we now recognize that those are independent claims, not actions on a contract, and as independent tort claims do not fall within the bar of any statute of frauds. And therefore, for the same reasons, we respectfully suggest that the fraud claim should be restated.
Counsel, you do agree that, or would you agree that your fraud in the inducement claim is based on alleged oral representations made by the appellee prior to the entry of the extension agreement?
Yes, that's correct, Your Honor.
Tell me what your case is again. Was it Griffin? Second DCA case that you think is close to this?
The case that I have is Griffiths v. Barnett, Bank of Naples, 603 Southern 2nd, 690.
And that case does not appear in your initial brief.
It's in the reply brief, Your Honor.
But that's your main case, though.
That is a main case, Your Honor.
Well, you told me before it was the closest to this case, I think. Maybe I misunderstood you.
That's correct, Your Honor. It's the one that among several we cite in the reply brief.
Because they don't get a chance to respond to reply briefs in our, the way we have our procedures here. So normally we don't like new issues raised in reply briefs, whether they're under the rubric of a case or an argument, because we have these formalized procedures that some people don't like. So.
And it's a sound rule, Your Honor, except in this case, the bank statute of frauds, we argue, is being argued for the first time on appeal.
You claim that they didn't really specify what the statute of frauds was in the trial court. Which statute applied in the trial court? Yeah.
I just refer the court to what the actual reply.
But in the answer brief, they do specify the particular statute of frauds.
So,
okay, I understand that.
There we are. Again, even if the court finds that we're not entitled to assert our affirmative defenses and counterclaim for fraud and inducement on remand, which we respectfully suggest we will, another important issue in this case, given the foreclosure crisis, is the issue of how the trial court should conduct sales of multiple distinct properties if foreclosure is required. The court has reviewed the record. The trial court repeatedly cited, at least orally on the record with my client's views, that those sales should happen serially to maximize the sale proceeds, and that being the default rule. Yet, unfortunately, in the final judgment, ordered, as the lender requested, a block sale all at one time. We think that while the trial judge is afforded properly wide latitude and discretion in ordering foreclosure sales, that discretion, unfortunately, was abused in this case because the other mandate the trial judge had was to adopt a mechanism to maximize the sale proceeds. And there was no finding or evidence as to why a block sale under these circumstances would be superior.
Would it be your position that, and you may have just said this, but would it be your position that the serial sale would sort of be the default position, and then there would be a burden of coming forward on the part of the lender to show some special circumstances why you ought to do a block sale?
That's what the authorities that I've reviewed said, Your Honor, and certainly no trial judge would be faulted for exercising his or her discretion to follow that. And I would respectfully suggest if a trial court, with guidance from this court, is going to choose to deviate from that rule of thumb, at least the record should reflect some reason as to why they're doing that.
Would it be appropriate for, the way this happened was a little bit unusual. There was a couple of post-hearing motions, and the court went one way and the other way.
Yes.
Would it be appropriate, if we were to vacate this portion of the final judgment of foreclosure, to remand it for further proceedings, or is that not the remedy that we should?
That is the proper remedy, Your Honor. I'll reserve the balance of my time.
Thank you very much.
May it please the Court. My name is Kyle Gavin, along with Christian George. I represent the appellee, Bisbee-Baldwin. The first issue on appeal in this case is whether or not the court properly excluded evidence of these alleged oral agreements. And I think what in the appellant's argument, I think it's clear they are seeking to enforce an oral agreement. And I think there are three important points to remember as you look at the cases in the authority. Three important facts in this case. One is we're dealing with alleged conduct or oral representations occurring prior to the execution of the written extension agreement. Secondly, the alleged oral representations directly contradict the written extension agreement. For example, they claim in the oral representations that Bisbee-Baldwin promised a 12-month extension, whereas the written extension agreement clearly provides for an extension only until May 5th of 2006. And finally, it's important to note that the underlying oral promises.
The extension agreement has a typo in the initial clause as far as the date. Is that right? It was executed in March of 06, but it recites. Or is this back to the date of the original loan, February 5th of 2005? Is that the original loan, or is that the date the extension agreement was?
The extension agreement was entered March the 2nd of 2006.
So it's a two-month extension.
Well, keep in mind that the earlier due date was back in November. So from November of 05 until March, the loan was not technically in default because the default hadn't been declared, but the payment was due and had not been made. So from November until March, the loan was not in technical default but was unpaid. And then in March, they extended until May. But the alleged oral promises directly contradict that and claim that what was promised was a 12-month extension. And those points are very important. And if I could answer one of the court's questions that was directed to the appellants, and that is whether or not there's any case or authority that says that the statute of frauds bars an affirmative defense. And the answer is neither party has cited to any case dealing specifically with the facts of this case concerning prior conduct. In other words, conduct before the execution of the written agreement. But what the cases do say, that and all those cases involve subsequent conduct. And the cases specifically note that we're dealing with subsequent conduct. And that's including the Griffiths case, the Brenowitz case, the Pavolini case, the Maynard case. We've all cited them in our briefs. But they're clear to note that they're dealing with conduct occurring after the written agreement. And it makes sense in those cases when you think about it. In other words, if you have a contract and one party, after the execution of the contract, induces the other party to breach the contract or default, for example, look, you don't need to make your payments. We'll roll this into a new loan at the end of the term. I believe it was the Brenowitz case where they indicated, look, if you buy stock in the bank, you won't need to make these payments and we'll just roll it into a new loan. Well, that's subsequent conduct that induces a breach.
But if you're induced in the commercial context to forego another alternative, such as alternative financing or selling the property or something like that, and that takes place before the loan is closed, that is barred by the statute of limitation, even if there is fraud. Is that?
Well, and the reason there being is because the written agreement, the bank statute of frauds clearly states that it applies to credit agreements and they need to be in writing. In this case, there was a writing, a subsequent writing, and under the parole evidence rule, the merger doctrine, that those prior negotiations, it may very well be that that's what the appellant wanted the lender to agree to, Bisbee-Baldwin, but it's clear that the subsequent agreement did not, in other words, that wasn't accepted. And there's a reason for the statute of frauds to prevent these very kinds of cases. But in the case of, you don't have the same issue when you're talking about prior conduct because the parties, and these are experienced parties here. They agreed to an extension. They did not include any of these other terms. And so that's why the statute of frauds will bar, even if it's a defense based on prior conduct, if it's based on prior conduct. And the same is true with the counterclaim based on fraudulent inducement. Once again, if the alleged fraud is directly contradicted by the subsequent agreement, there can be no fraudulent inducement. And secondly, if your alleged fraud is based on an oral promise that is required to be in writing by the statute of frauds, then that can't serve as the basis for a fraudulent inducement claim. And this is different. For example, if I misrepresent a material fact, if I'm selling a car and I say this is the 2009 model, I've misrepresented a material fact and that can be fraudulent inducement. By the same token, There is case law that says if you misrepresent a promise, in other words, you make a promise that you have no intent in keeping, and they can prove that, that can be a fraudulent inducement claim if that promise is not subject to the statute of frauds. But the cases dealing with an underlying promise or alleged promise that is subject to the statute of frauds, what the courts have held is that you can't, by mere semantics, convert a breach of contract case into a fraud case. And so I do want to address one issue that's been raised also, and that is that there wasn't proper identification of the statute of frauds defense by citing the bank statute. I'm not aware of any authority, and in fact the Supreme Court approved form for the statute of frauds defense, and the Rules of Civil Procedure doesn't even use the word statute of frauds, and they don't cite a particular statute. So I think merely by raising the statute of fraud defense, that was sufficient to raise that issue. Getting to the next issue, and that is regarding the sale of these properties. It is true a trial court has discretion. They can sell properties in a series, or they can order the sale en bloc. In this particular case, it was presented to the court there are certain administrative difficulties with selling, in this case, in multiple counties in a series. And while I concede that those difficulties aren't insurmountable, it's certainly a factor that the court can take into consideration when determining which way to go here. The more important factor, though, was the prejudice to the lender in a case like this, where there is one loan secured by what in essence is 5 parcels. 2 of the parcels are more or less together, but secured by 5 parcels. The problem here, particularly in the market that we find ourselves in today, is what does the lender bid in if it's sold serially? In other words, what does the lender bid in the first case? And if I could use an example, let's say the foreclosure judgment is in the amount of $3 million, and there are 5 parcels, and as usually is the case, the lender is saying each one is worth, in my example, $500,000. The borrower is saying, no, they're all worth $1 million. Well, if you serially sell all of these properties...
I understand. You made that argument in your brief, which I found kind of intriguing, because it seems to me like the block sale raises that problem far more than the serial sale. Are you going to bid a lump sum at the block sale for the 4 parcels?
Yeah, well, we would build the loan amount.
The final judgment is $3 million plus interest. How are you going to allocate your bid at the sale if it's a block sale?
Well, if it's a block sale, that's just it. We wouldn't have to. We would bid in the total amount.
Doesn't that give the lender really a tremendous amount of leverage in this kind of situation if it really is oversecured, as you say it is?
I think that's in dispute, and it was brought up in the trial court.
I understand that, but if it is oversecured based on even their conservative appraisal, doesn't that gives your side a pretty good bit of leverage, it seems like?
Well, again, that's within the trial court's discretion. It was certainly argued to the court that that was the case. It was, from the lender standpoint, it was also presented that it creates a difficulty. And the lender can, using my example, if they bid in too much for each parcel, then the lender, for example, if these properties are only worth $300,000 apiece, and the lender bids in $500,000, nobody else bids. I mean, that's the worst case. Nobody else bids, and the lender.
Was there an appraisal of record in this case appraising the properties at in excess of $9 million?
There were proffered appraisals for that amount. The objection to those appraisals was that they were not as-is appraisals. Many of them were conditioned on if such and such and such is done to this property, it will be worth that much.
Well, with all due respect, though, if we were to weigh the evidentiary values of those appraisals versus, with all due respect, the evidentiary value of the representation that your side made about the clerk having said in a phone call that they'd have some difficulty, see where I'm going with that? I mean, you might not like their appraisals, but on the other hand, at least they had appraisals. Well, what you all had on your side was a representation that the clerk said, well, this is an administrative issue to sell these properties in 4 consecutive weeks.
Well, I'm not sure that it was a requirement to do that any party have appraisals for the trial court to make this decision. Certainly, when you get to the deficiency stage.
No, but you're right. We're not at a deficiency stage, so we're not as concerned with fair market value, but we are concerned with Mr. Healy's proposition, which I think does have some support in the law, that there's kind of a default position here that you auction off the security serially unless the lender shows either undue hardship or prejudice. Now, you've alleged both of those, but I don't know that there's an evidentiary showing of either of those.
Well, I think what happened in the trial court below was just the practical considerations of what has to happen in a situation where it's done serially. The lender's got to make, even though it had one loan, that in effect, when you do it serially, it turns into 5 loans because they've got to make an individual decision. What is this piece of property worth? If it's worth $500,000, everybody goes home happy if that's what the bid is.
Do you agree that the local property appraisers' records reflect that the tax valuation for these properties exceeded $5 million? I don't have a problem with what was stated in the brief as far as what I don't recall the exact amount, but what the property tax appraiser said. I'm not sure that's an accurate projection of the values or what they would bring, particularly in the record to dispute these valuations by the property appraiser and or the MAI appraiser.
Well, there's certainly in the record, in the testimony before the trial court, disagreement that those appraisals were valid because they contemplated certain work being done. In other words, if the road is built, then the property will have this value. Well, the road hasn't been built, and that type of thing. And so our objection to Bisbee-Baldwin's objections to the appraisals is because they were not as-is appraisals. They were as could be appraisals. And for that reason, were not valid. But again, if the lender is forced to choose an amount, and which is particularly difficult in this climate, as to what to bid in, let's say for the first parcel, and nobody else bids, you may be holding a property that you've bid in $500,000 for that may only be worth $200,000, and there's no way to recoup that difference. So in effect, you've divided this loan up into 5 different loans, and that's the prejudice to the lender in a case like this. And the standard is an abuse of discretion standard, which simply means that no reasonable person could hold the way the trial court held. And even if reasonable minds disagree with what the trial court held, I believe the only valid basis for reversing that is if the court finds that there is no reasonable basis for the block sale. And I don't think that can be said, that there is no reasonable basis for the block sale, particularly in this case where the lender could be exposed to market conditions that would cause them to bid more than properties are actually worth.
Now, in terms of the way this happened, you had the judgment, and you had a motion for rehearing, which I think was their motion for rehearing. And up until that point, we've still got a sort of serial sale. And then you've got your motion, emergency motion for rehearing, which was ultimately granted by the judge, given us the situation.
That's correct. Okay. And that's where the argument was made that this would be prejudicial, in addition to the clerk issues, that this would be prejudicial to the lender to do it other than in a block sale. There was one third issue on the appeal, and I think the reply brief made clear that the issue with regard to the whether or not the due diligence fee was properly included as a secured claim is, I believe we've resolved that now, where that was properly included as a secured claim. I see my time is up. I believe that the court should uphold the trial court's ruling in this matter, both as to the exclusion of the evidence about.
Can I ask you? I'm going to ask you one more question because I want to be sure about this. I am following your argument about allocating this money, and I followed it in your answer brief because it really is difficult to tell what one parcel's worth, and you may end up getting, even if you go in good faith, you may still end up with 70% or 60% or whatever after the fourth one's gone. But was that specific argument made to the trial judge?
It was made in, when you say specific, they clearly raise the difficulty in knowing what to bid in. There is not a record of the actual hearing before the trial judge. So we don't know, as of the record, what exactly was said to the trial judge.
It just strikes me that that's something that, to a sophisticated person like you or your client, that may be apparent, that you're going to run into these problems and you're down the road 3 sales and you've only recouped 40% of your money and you got a problem there. But it just seems like maybe there ought to be some sort of evidentiary showing to balance that off with whatever evidentiary they claims that the loan is oversecured. That's my suggestion.
Yeah, but counsel, without any evidentiary showing in this case, would it be pure speculation to say what the values will be, those properties once they're sold?
I think that's inherent in any sale, is that the lender always has to speculate what the value would be worth when it bids in its amount. Where it becomes an issue is in the deficiency. And in response, Judge Kahn, to your comment, I believe that this issue, my prediction is the parties aren't going to agree whether 40% of the loan has been paid. We'll say 40% of it has been paid. They're going to say it's 80%. And that's why I think a block sale avoids this piecemeal, what could be piecemeal litigation after every sale, trying to litigate what the deficiency is after that sale. Thank you.
Thank you, Mr. Gavin.
In brief rebuttal to several of the points raised. First, the issue.
Well, answer that last point first. You get an appraisal that says that whatever the first parcel is worth $1 million. They contend that they bid in good faith $150,000. Is that not a matter that needs to be resolved at some point in these proceedings?
Yeah, typically the issue of bidding and adequacy is resolved at the deficiency stage.
But it's resolved with one proceeding for a deficiency sale to find out if there's any sort of leftover liability there.
That's right, and it's perplexing to me that the lender is casting the issue of how the sale is to proceed as the lender's risk they're going to bid too much. I respectfully suggest, I don't see that as a concern. They can value the property as they see fit, and the mortgage itself valued each parcel for release purposes. So, I mean, the lender, when it suits its purpose, can choose how to value its parcel.
So that's your suggestion is that it would be almost as if each one of these sales were different, truly different, and they would be obligated to make a fair bid at each sale. And
that strikes me as the fairest way to all parties concerned. I mean, respectfully, the issue should be, is the lender advocating, I think they are, a sale regime that they may bid too little for. Judge, they were appraisals for $9 million, and yes, the tax assessor did appraise it for more than $5 million, and we believe those were as-is appraisals. And there was no contradiction offered by the other side questioning those valuations. So, you know, the risk for my client is that you come in with a sale regime that these things are taken by a song, probably by the lender, who's the only one that's going to be able to bid on this much property all at one time. That's not the mechanism we want. We want to do a mechanism that will maximize the possibility of sale proceeds. And
that will minimize the possibility of a deficiency judgment against your clients.
That would be of interest to us, too. Or if these valuations are all correct, even in a foreclosure sale, maybe money in their pocket. It does happen. It's rare, but it does happen. Respectfully, on the issues of the validity of our affirmative defenses and counterclaim, the bank statute of fraud merely says what it says. It only bars actions on credit agreement, doesn't reach our defenses. This distinction of when the misrepresentation occurred, pre or post agreement, is not a distinction that has any significance in the case law to date. And I would suggest there's nothing in the rationale of the statute or the case law that would cause this court to draw that distinction, drawn by no one else.
Do we need to address the due diligence fee?
No, Your Honor. We've withdrawn point 3. So the other side is correct on that. So respectfully, Your Honor, Your Honors, we would ask that this court reverse the judgment, remand this case with directions to the trial court to reinstate our affirmative defenses, the counterclaim, and with the direction that if a foreclosure is later ordered, that the sale proceed serially rather than all at one time.
Thank you. Thank you, counsel.